For those of you who don't know me, my name's Claire White. I'm one of the partners in the personal injury team here at BTO, and I'm delighted to be introducing this seminar today, which is going to be presented by one of our associates, Angus Gillies. Before we start, just a couple of housekeeping points. I wonder if you could all check that your microphones are on mute, just to make sure we don't get any unwelcome feedback. And secondly, to remind you that this seminar is being recorded. So again, if you don't want your face to show at any point during the recording, please make sure that your camera is also has been switched off. So just to kick off today, I'm going to hand over shortly to Angus. Again, for those of you who don't know Angus, he's one of the associates in our personal injury team. He's very experienced in dealing with all kinds of personal injury claims, but he has developed something of a specialism in the last few years in dealing with claims, particularly arising out of accidents which have occurred on foreign shores, holiday claims, cruise ship claims, that kind of thing. But today he's going to be looking a little bit closer to home and dealing with what we think is maybe a little bit of a topical issue, because the home-based hospitality section industry is hopefully opening up after the pandemic. So Angus is going to take us through the duties and the responsibilities of those operating in that industry from a general point of view, and then he'll do a little bit of crystal ball gazing to the near future to think about what specific issues might arise out of the COVID pandemic and how those might impact on claims affecting that sector. So without further ado, I'll hand you over to Angus. I would encourage you, if you have any questions, to feel free to type them into the chat facility as you go along, and we'll pick those up at the end. Or equally, you could raise your hand at the end and unmute yourself, and feel free to ask any questions directly of Angus at the end of the seminar. Without further ado, I'll hand you over to Angus now.
Thank you very much, Claire. First of all, thank you all very much again for joining today for this presentation on staycation claims. Good news yesterday about further restrictions being lifted across the country, and we're getting closer to something resembling normal life. Foreign travel is now opening up, and the Scottish Government announced its own traffic light system yesterday. However, I imagine the majority of people in the UK will need to content themselves with a staycation this summer. I, for one, will be staycationing in the exotic climes of the Highlands of Scotland this year, although I'm struggling to get my mother's old caravan booked in anywhere, which is probably a sure sign that we're on course for a UK staycation boom if I can't get away with a rainy week in the Highlands with the caravan. So to help us all through this process today, I've put on a background filter of a nice, warm, sunny beach, so we can all pretend that we're on a nice foreign holiday for the next 45 minutes. I, for one, like to attend seminars on occupiers' liability to help me relax on holiday, and I'm sure you're all the same. The focus of my discussion today will be on public liability claims, the potential personal injury claims that we may see from the public. My presentation will focus largely on hotels in the UK and their duties to the public as occupiers. However, the law and the general principles I'll be discussing will, of course, apply to pubs, restaurants, tourist attractions, and apply to also to holiday accommodation providers of all types and occupiers in general. Whilst I won't be covering employers' liability today as well, I would simply point out that employers who are occupiers owe a duty of care to their employees as well as members of the public. Moving on to the next slide. I thought it'd be useful to start with a brief summary of the relevant law, the legal framework in which imposes certain duties of care on occupiers in the UK. So in Scotland, we have the Occupiers Liability Scotland Act 1960. And this imposes a duty on the occupier of reasonable care in respect of dangers arising from the state of the premises or anything done or admitted to have been done on them. So it's quite a broadly stated duty that relates to dangers arising from the condition of the premises. In England and Wales, as many of you will already be aware, this the duty of care is slightly more restricted. The 1957 Act imposes a duty on the occupier to take care that visitors are reasonably safe in using the occupier's premises for the purpose for which he is invited or permitted to be on the premises. So the 1957 Act involves a consideration of the purpose for which the claimant is using the premises when the accident occurred and whether he is a lawful visitor. And the 1984 Act was enacted to regulate the duty of care which an occupier owes to unlawful visitors. And that's a key difference between the English and Scottish positions. Occupiers in England owe trespassers and unlawful visitors a duty of care only in limited circumstances. In Scotland, the duty of care applies irrespective of the capacity in which the visitor is on the premises. It doesn't differentiate between lawful visitors and trespassers as such, but this will certainly be something that will be taken into account when the court is deciding foreseeability, for example. The reason I mention that is many of you will be aware that in England and Wales, a lot of disputes turn on whether the premises is being used for the purpose the occupier was allowing the premises to be used by the guest, and also whether somebody's a lawful guest or whether they are a trespasser. There's also the common law duty of care. And claims directed against occupiers, it's quite common to see both the legislation and the common law relied upon by the pursuer. The reason being that the common law duty of care is wider in its scope. It's a general duty of care owed by the occupiers, such as hotel operators, by virtue of their control over the premises to visitors and employees. It applies to dangers in a general sense and not just those arising from the premises, like you see in the 1960 Act in Scotland. The duty is to put in place proportionate measures to deal with risks arising from identifiable sources of danger. So as you might expect, the test is one of reasonable foreseeability before liability will attach to an occupier. Turning now to a couple of recent examples of the court considering the occupier's duty of care. The Al Najjar case is quite a shocking case involving some guests being subjected to a brutal violent attack by an intruder. The attack happened at night when there was only one lobby officer on duty to supervise the front door as people came into the hotel. He had other duties such as inspecting and looking after the reception area and the bar. And this is when the intruder got in, when the lobby officer wasn't on the front door. Now, at trial, virtually every aspect of the hotel security provision was challenged by the claimants. It was accepted that the hotel owed a duty of care to take reasonable care to protect guests from injury caused by third-party criminal acts. In this case, it was reasonably foreseeable that a third party might gain entry and injure the guest by criminal assault. On this occasion, the hotel security, however, and their attitude towards security was adequate, and it was held that the hotel had exercised reasonable care in the circumstances. The White Lion case involved the death of a hotel guest who had fallen from a window from his room in the hotel from the second floor. The guest had returned to his hotel room after attending a wedding. He had opened a sash window when sat on the sill, and because of a fault in the window, he had to hold open the sash in order to get out of the window or lean out of the window. I think we understand he was smoking or rather getting fresh air at the time. He unfortunately fell to his death from the window, and the deceased widow successfully claimed damages against the hotel under the Occupiers Liability Act 1957, subject to a 60% reduction for the deceased contributing negligence. The court found that the hotel had failed to carry out a suitable and sufficient risk assessment. As a result, they failed to identify the fault with the sash window and that the risk that posed to guests, such as the deceased. The claimant was in his hotel room on a hot day with no air conditioning. It was understood that the claimant had been drinking prior to the accident, but it was held as foreseeable in these circumstances that someone would open a window to smoke or to get some fresh air. The cost of implementing a preventative measure was very low. It was found there could have been restrictors put in place at the cost of £7 or £8 each, for example. The court observed that, in their judgment, there was a material difference between a visitor to a park or even a pub and a guest in a hotel. During the time the guest's in the hotel room, that hotel is essentially a home from home for that guest. The guest in the room may be tired, may be off guard, relaxing, may well have had a little more to drink, and he may be tempted to smoke out the window or even open the window for fresh air, especially when there's no air conditioning. Now, the judge in that case observed that these are just facts of life for any hotelier, and these are risks that the hotel ought to have foreseen and addressed. And in the case, a good example of the factors the court will take into consideration when deciding if liabilities should attach to an occupier such as a hotel owner. The risk of the fall from the window was foreseeable. The risk assessment was inadequate. There was inadequate preventative measures put in place by the hotel, and the cost of implementing preventative measures was very low, which is also important in deciding whether there has been negligence. The case also demonstrates how hotel owners are almost a special type of occupier, in that they need to be aware of the unique risks from which guests must be protected when they're staying in the hotel, or what the court described as a home from home. There was a valenti defence run by the defenders in this case. In other words, that the deceased, by opening the window and leaning out of it, voluntarily accepted the risks associated with that. However, that was not accepted by the court. It could hardly be said that the deceased was fully aware of the risks when the hotel themselves were saying that they weren't aware of the risk posed by the fault in the sash window. There was also some arguments as to whether the deceased had become a trespasser at the point of opening the window and leaning out of it, and whether he was using the premises for the purpose for which he was permitted to do so by the occupier. All of these arguments were rejected by the court. So I've listed there some of the challenges ahead, specifically in the context of COVID claims. It appears that we're well on track now to the majority of the coronavirus restrictions being removed. However, there's a chance that some of the restrictions will remain in place over the summer months. I think the situation remains somewhat unpredictable. In Scotland, for example, infection rates have unexpectedly risen in Moray, and that area of Scotland may remain in level 3 longer than the rest of the country. Some of the islands will go to level 1 quicker than the rest of us, for example. Hotels will have to continually monitor the situation and adapt. At the very least, hotel operators will need to be able to demonstrate adherence to the government guidelines and that their health and safety regime was designed around this. We could well see a level of social distancing being in place over the summer. Face-to-face interaction between staff and guests may still need to be minimised. Sanitizer dispensers, PPE throughout the hotels. All of the kinds of things that we're now used to seeing in relation to COVID preventative measures. I think hotel operators are understandably going to be concerned as people start to come to the hotels and now the restrictions are being lifted, that a guest is going to claim that he or she contracted COVID whilst attending the premises, and also be concerned about fraud and opportunistic claims. The good news is that when it comes to COVID claims in particular, there are strong lines of defence, particularly when it comes to public liability claims. When it comes to defending COVID claims, all of the components of the claim are likely to be an issue. So the scope of the duty of care will be an issue in any given case. There's whether there's been a breach of duty in the first place, and causation will certainly be hotly contested in any one claim. Knowledge of the risk will determine the scope of the duty of care. So with COVID, there's reams of information and guidance, I think possibly 50 or more subordinate pieces of legislation in addition to the COVID acts have been passed. Big hotel chains in particular will be considered to have greater than average knowledge of the risks of COVID. And the sector-based guidance for the hotel and hospitality industry will evolve, and in turn, so must the health and safety practices of these hotels. No measures are going to be 100% effective against COVID. The occupier is only expected to take reasonable care for the public, not guarantee complete safety. In defending these claims, we would hope to be in a position to demonstrate thorough and well thought out COVID risk assessments, evidence of a suitable training regime, importantly, supervision and proper implementation of the health and safety regime as well. Evidence that the changing COVID guidance is being monitored and methods of work have adapted accordingly. And when defending these claims, it's likely that sector-specific expert input may be required to assess whether the occupier or employer has implemented a suitable health and safety regime. These claims are going to be much more difficult for the claimant to be successful at than, say, for example, the traditional holiday sickness claim that you get, where the claimant can demonstrate that he or she stayed at the resort for the duration of the holiday and only ate at that resort for the entire trip, and therefore they must have become ill as a result of the negligence of the hotel and the restaurant. These COVID claims are going to be much more difficult than that. However, the capability of claimants and pursuer firms to find new and interesting ways to bring claims against occupiers should not be underestimated. Just to give you an example, I recently successfully defended a claim involving a hand gel dispenser. The pursuer was an elderly gentleman, and he was using an air bridge when boarding a ship from a dock in Southampton onto a cruise ship. And the air bridge had a handrail along it. He alleged that the hand gel caused his hand to become slippery, and when he used the handrail, his hand slipped along the handrail, which then resulted in him falling to his injury, quite a severe injury, in fact. Now, the allegations of negligence were centred around the positioning of this hand gel dispenser at the start of the air bridge and the start of the handrail, and nothing else really. We persuaded the pursuer to abandon that claim because it was clearly lacking in merit. However, the case caused me to reflect on what could potentially lie ahead for occupiers. For example, had the claimant presented a case centred around the type of gel which was applied, not absorbing quickly enough into his hands, causing the hands to be slippery, and when having to walk along a corridor or an air bridge which has a gradient, he maybe had more of a stateable case if those were the basis of his, if that was the basis of his claim. Is it foreseeable that an elderly passenger in those circumstances may have an accident and fall? I think that can certainly be argued. I highlight this as I think it demonstrates the potential difficulties for occupiers in addressing potential risks in the current climate. One could be forgiven for thinking that installing a hand gel dispenser is relatively uncontroversial, and in fact a good indicator that health and safety has been taken seriously by the occupier. However, I think there's a danger that some occupiers may become too focused on the narrow issue of trying to prevent COVID without remembering the general wider duty of care and looking at the broader health and safety picture. For example, is the hand sanitizer station, have you positioned that in a way which could cause a potential tripping hazard? Or is it leaking? Is it causing a slipping hazard? These things still have to be risk assessed and identified. These types of COVID claim as well. Well, sorry, that claim I referred to there may be a sign of things to come, and that possibly pursuers will be encouraged by developments north of the border, such as the introduction of qualified one-way cost shifting in Scotland, which takes away many of the risks involved in litigation. They may be encouraged to run more claims like that, which don't have much merit in a legal sense, and take a gamble where there's little risk in them doing so. The situation is also open to abuse and fraud. I think any Google search will bring up a number of law firms which are advertising representation for COVID-related personal injury. And this will no doubt encourage these types of claims. The scope to exaggerate low-level symptoms, to be dishonest about the timing of infection, and the alleged source of the infection is significant, I think. There are, of course, many ways to investigate these matters and to challenge them through consideration of the medical records, social media searches, employment records, stuff like that. But I anticipate that certain firms will try and keep some of these claims relatively low value, so that insurers will be forced to consider the economics of defending a claim for alleged COVID-19 infections, which can be considerable. Another tactic that we may see from pursuers is that we may be presented with bare allegations of negligence that they caught COVID in a certain hotel. The guest may point to certain breaches of health and safety which they allege they witnessed, and then use that as a basis to try and fish for evidence and try and build a case against the insured. We often see pursuer firms do this in Scotland by way of a summary application under the Administration of Justice Scotland Act 1972, which is a pre-litigation court procedure which allows pursuers to recover documentation and witness details from potential defenders pre-litigation, so before raising the claim. They may try to abuse this process in COVID claims to try and get the claim off the ground where the evidence is otherwise lacking. We also often see subject access requests under the Data Protection Act being used for this purpose also. There may be attempts to recover medical information from employees and guests relating if there's been an alleged outbreak, for example. This will be highly controversial. Again, there are defences open to, and ways to stop this from happening, and we are here to assist you with this. Causation is going to be a massive hurdle for pursuers to overcome in the context of public liability COVID claims. I think this is already well understood by insurers and pursuers alike. For example, there are likely to be a number of competing causes for a COVID-19 infection. The pursuer will need to prove in a balance of probabilities that an alleged breach on the part of the hotel was the cause of the infection they suffered. This is not going to be easy to do, given that COVID-19 is an airborne virus. However, pursuer firms being what they are, they're likely to find imaginative ways to make claims against hotels and other operators in the tourism industry. They may use alternative approaches to establishing causation, such as arguing that negligent exposure to COVID during a stay in a hotel caused a material increase of the risk of infection, for example. We may see a shift from the traditional causation but for approaches to pursuers trying to adopt the risk-based or statistical-based approach to causation, typical to disease claims. However, again, these are well open to being challenged and defended. All of these approaches when it comes to public liability have weaknesses for the claimant. So that's the good news. I think there are good ways to challenge and possibly fully defend COVID public liability claims when it comes to alleged COVID-19 claims and infections caused during this guest staying at a hotel, for example. So whilst pursuers will no doubt become creative in the way they raise COVID public liability claims, we as defenders will also become creative in the way we defend these claims and challenge the pursuers on as many fronts as possible. So, for example, there's never going to be 100% guarantee that you're going to not contract COVID-19 when you go outside or you're a guest in a hotel. And there could be relevant validity arguments to run. So what I've provided there and on your slides is two examples of Scottish cases where causation arguments were successfully advanced by defenders, but these were more traditional tripping cases, but again, useful to refer to, and a good sign that, again, many of these claims can be defended, and we are, of course, here to help you with that. That wraps up my presentation for today. If you have any questions, I'll be more than happy to take them now, or also Claire as well.
Thanks, Angus. Yes, if anyone has any questions for Angus, I would encourage you to use the chat function and type them out, and I'll get to them. I do have one question, Angus, which you might be able to answer. You touched on the pre-litigation processes and procedures that are available for claimants to try and fish for information. So I'm just wondering what, I can imagine the kind of letter that a hotelier might receive demanding access to all sorts of information and records, some of which might relate to employees or other guests. And some of these letters can be quite sort of threatening and demanding in their terms. I'm just wondering what advice you would give to an operator who receives a letter like that in terms of what the response should be and how they should deal with it.
Yeah, well, especially with subject access requests under the Data Protection Act, These things need to be managed very carefully. A lot of the times they're used to seek stuff which they're not entitled to under the Data Protection Act or the GDPR. So, for example, a lot of the times they'll look for risk assessments and liability reports, etc., stuff that doesn't contain any personal information or personal data about the claimant themselves. They're not entitled to that sort of thing. But also there's the very sensitive issue of third-party data, which if they're going to try and prove that there was an outbreak, or, for example, if they're going to try and establish vicarious liability for an employer's liability claim, they may be looking for medical information relating to other guests and employees to try and establish causation. Now, third-party data protection cannot be given, generally speaking, given out without their consent. There are ways in which it can be given without their consent, but I would submit that in these circumstances, consent will have to be obtained. And unfortunately, for insurers and occupiers, they will need legal advice on these matters, because it's something which has to be dealt with. You need to comply with a subject access request as much as you're obliged to do so under the law. But many times this process is abused by claimants to try and fish for evidence and look for stuff which they're not entitled to. So yes, they can be very threatening and very scary, and you get kind of deadlines for complying with them. But I think the message to occupiers and to insureds and to hotel operators and the like is to seek advice on what you should be disclosing when you receive a subject access request under the GDPR. And also, a lot of the time the summary applications are used, and this is core procedure. So hopefully that will make its way to the insurer and the insurer's solicitor to deal with. But again, these are quite often used to fish for evidence to try and get formulate a basis of a claim. Summary applications should not be used for that purpose. There already has to be a prima facie case of negligence in place. And that's why we're quite successful in defending them, because a lot of pursuers use it inappropriately, and where there isn't a prima facie case of negligence already, these summary applications can be defended. So you get what's through the post a writ and other documentation like that, seeking information such as risk assessments and the like, and witness details and CCTV, stuff like that. Again, these are things which need to be dealt with by a solicitor given its legal procedure, and need to be dealt with properly. So I suppose to sum up my advice for those types of things is to seek advice and encourage your insureds to seek advice as well.
Yeah, it sounds as if caution is the way to go, and there could be some interesting battles ahead then on that aspect of things. Well, I'm just checking the chat. I don't think we have any written questions. If anyone wants to put their hand up and has a question, feel free. Otherwise, as always, if you have any questions for Angus, feel free to contact him via the usual channels after the meeting, and I'm sure he'll be happy to answer any further queries that anyone has. Other than that, we are out of time, so I won't keep you from your lunches. Thanks very much again for joining us today, and hope you found something useful in Angus's talk. And we'll see you next time. Thanks then.
Thank you very much.